Hello and welcome to Topic 3, Lecture 1, where we're going to be learning about the incorporation of the Bill of Rights. Okay, so what are we going to be learning about in this lecture? Well, the first thing we're going to do is we're going to define what we mean by the incorporation of the Bill of Rights. Next, we're going to ask the question and answer, hopefully, or do a little bit of investigation about whether or not the framers of the Bill of Rights intended the Bill of Rights to apply to the states. Then we're going to review the landmark case dealing with the question of whether or not the Bill of Rights applies to the states. And then landmark case is Barron versus Baltimore. And then we're going to end the lecture by describing the role that the 14th Amendment plays in the application of the Bill of Rights to the states. So let's go ahead and get started. Okay, so as I was growing up and getting more and more politically active, I, really got, involved in civil liberties and wanting to exercise my rights, as do many Americans. And I remember that I was at some sort of event and they were handing out these little paper copies of the First Amendment. It was just the First Amendment. And it was like a sticker and you could pull off the back and you could adhere it to things. And I was like, yeah, I'm going to be loud and proud and demonstrate my support for the First Amendment. So this was a long time ago and I had a VCR. You guys might remember what a VCR is. It's kind of like a modern day equivalent of a DVD player, but we don't even use those very frequently anymore. And so when I got home, I pulled off the sticker, and I stuck it on my VCR and I was like, hell yes, this is my VCR and I can watch whatever I want to, I could, if I want to watch horror movies, if I want to watch porn, whatever, it's my right, my freedom of expression, right? And so, I put it on my VCR and, they're displaying my support for the First Amendment. But one day I was, putting a video in there and I looked down and I started reading the First Amendment. And there it is up there on the screen. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the rights of the people peaceably to assemble and to petition the government for a redress of grievances. And I was reading that, and I lived in Indiana at the time, which is a pretty conservative state. And I saw that word Congress, and I was like, wait a second. Congress shall make no laws. And then I was like, again, keep in mind, I was really young. I hadn't taken a government class yet. And I said, oh, Congress shall make no law. Wait a second. Does that mean that the First Amendment only applies to the actions of the federal government? Or does the First Amendment apply to the actions of the state government as well? In other words, are my right to freedom of expression, the right to, protest, and the right to have freedom of the press? I mean, is that only limiting what the national government can do to restrict those rights? Or does it apply to state and local governments as well? And that's what the issue of the incorporation of the Bill of Rights is about. That's what you're going to be learning about in this chapter. Does the Bill of Rights constrain only the actions of the federal government? For gosh sakes, it says Congress there. Is it literally only Congress that the Bill of Rights applies to? Or does Congress extend to the actions of any legislative body? In other words, does that word Congress imply that this isn't a restriction that's just placed on national government, but it's implied that it also extends to the actions of state governments and local governments as well. So that's the question that we're going to be tackling in chapter 3. And it's our last foundational chapter before we move on and actually begin our exploration, starting with the right of your religious freedoms. And so it's a really interesting concept. And like the other foundational chapters we've done up to this point, it really gives you the groundwork you need for fully appreciating the cases that we're going to be learning about for the rest of the semester. Okay, so when we're talking about the incorporation of the Bill of Rights, what are we talking about? What does that mean? So let's do some definitions here. Well, the concept of incorporation is a constitutional principle through which selected parts of the Bill of Rights are made applicable to the states. And so that's what the incorporation of the Bill of Rights it means. That's what this topic is about, as we sort of, you kind of already are getting that sense. And so incorporation is applying the Bill of Rights to the states and asking the question about whether or not the Bill of Rights does, in fact, apply to the states. Well, I think as many of us know, and if you've taken an American government class, and if you've started reading Chapter 3, you know that almost all of the provisions in the Bill of Rights have been incorporated to the states. They do apply to the states. And that's where we are today in 2022, right? I mean, that they apply to the states. And that incorporation of the Bill of Rights to the states is basically the movement towards nationalizing the Bill of Rights, okay? Making it a document that doesn't just limit the actions of the federal government, but that extends those rights to cover basically any form of government that's trying to restrict your rights, including state governments and including local governments as well. And so today, for the most part, the Bill of Rights has been incorporated and applies to the states. But that has not always been the case. In fact, for the nearly 100 years, for the first 100 years of of America's history, and here we're talking about America not as colonies, but as actual, an independent nation state. So for the first 100 years or so, the Bill of Rights was seen as only applying to and thus limiting the actions of the federal government. And so for, nearly 100 years, you basically were, individuals had sort of two documents that guaranteed their rights. There it says the dual guarantee of rights. And so you had the Bill of Rights, which only limited the actions of the federal government, okay? So Congress couldn't make a law abridging your speech. Congress couldn't make a law, trampling upon the press. Congress couldn't make a law that would allow cops to enter into your domicile without a warrant. All of that was limited by the Bill of Rights. But if it came to your state government or your local government, it really depended on the kind of Bill of Rights you had at the state level. So if your state Constitution said that your state government can't abridge your free speech or establish a religion or needs to have a warrant to do a search, well then your rights were guaranteed at the state, but it was through your state constitution. So you really had these sort of dual or double guarantees of rights. Some guaranteeing of rights that limit what Congress can do to you, what the federal government can do to you, but also another Bill of Rights that applied to the role that the actions that the states can take on you. And keep in mind that states at this time and even today, states are the ones that are most likely to intrude upon your liberties, right? It's going to be your state government. It's going to be your local government in terms of placing limitations on protest or placing limitations on your local press or instructing law enforcement about what kinds of searches that they can engage in. Those are all local and state sort of endeavors. And so the fact that the Bill of Rights maybe only applies to the national government, that really leaves a lot of a person's personal freedoms uncovered, unprotected, particularly if their state did not have a robust Bill of Rights, which many did not. So for the first 100 years, the Bill of Rights was not seen as applying to the states. That changes following the Civil War. So following the Civil War, there are a series of amendments that are added to the Constitution, basically to send a direct message, not just a direct message, but to really limit what states can do, particularly those states that seceded from the nation, fought against the Union, and now want to come back in, right? And so the 13th, the 14th, and the 15th Amendment were added after the Civil War. And it's the 14th Amendment in particular that was added in 1868 that opens the doorway for the Bill of Rights to be incorporated to the states. And so today, as I mentioned, and as your textbook mentions, nearly most, but not all, there's still a couple of provisions of the Bill of Rights that haven't been incorporated to the states. But today, most of the provisions of the Bill of Rights applies to the actions of both the federal government, but also the actions of the state government and also the actions of the local governments. So let's take a look at how this took place. Okay, so now that we've got the definition of incorporation, we've discussed that, and then you get sort of the big picture in terms of the changes in thinking about, whether or not the Bill of Rights applies to the state. For the first 100 years, it didn't, and then after that, it slowly got applied to the states. So, we kind of get the big picture going here. Before we move in and look at the details of incorporation, let's take a look at this question about whether or not the framers intended for the Bill of Rights to apply to the states. Now, we just got out of a discussion that looked at the different legal methods that Supreme Court justices use when trying to decide a case. And a really popular method that justices use is originalism, right? Sort of saying, here's the Constitution. What did the framers intend when they wrote these words down in this Constitution? And so trying to ask the question about whether or not that word, Congress, shall make no law, whether or not the framers intended that to apply only to Congress, or whether that word was sort of a placeholder for, that yes, Congress, but it implies other governments as well. Historians, judicial historians have, tried to determine like what the intent of the founders was. So the first Congress did consider this issue. Now, keep in mind that the Bill of Rights, the first 10 amendments to the United States Constitution, we talked about this earlier in this semester, that initially the Constitution was ratified with Article 1 through 7 with no Bill of Rights. But that ratification was a process of compromise. And so it was like, hey, states, ratify the Constitution, and the first act of this new Congress will be to create a Bill of Rights. And so the first Congress, they, asked James Madison was endowed with that, or charged with that job of creating the Bill of Rights. And so we know that Congress did consider the issue. And what Congress considered when it was, deciding to pass the amendments that James Madison had created, we know that one of the amendments that James Madison put forth to Congress, but that was never approved by Congress, is what's known as Madison's 14th Amendment. Not to be confused with the 14th Amendment that was added post-Civil War in 1868. And what Madison's 14th Amendment stated is it says, no state shall violate the equal right of conscience, freedom of the press, or trial by jury in criminal cases. Okay? That's what Madison's 14th Amendment said. It actually stated, it specified that this amendment should apply to the states, and that states can't take away your right to conscience. That's loosely sort of defined as that states can't force you to participate, to draft you into war. That if your religious beliefs, if your conscience says that you cannot fight in a war, that states have to respect that. It could broadly be interpreted as sort of a broad protection of the rights of conscience, like religious beliefs, freedom of the press, and trial by jury. So basically, Madison's saying states can't do this. It kind of opens the door to say, okay, if you're saying states can't do this, does that mean that the other provisions of the Bill of Rights apply only to Congress? Well, in a way, it's kind of a moot point because, or maybe it's not. But when Congress was presented with Madison's 14th Amendment, which is above there, they rejected it. They did not approve it. It is not one of the amendments that went to the states for ratification. Remember, there were 12 amendments that went to the states, and 10 of those were ratified, thus making up the Bill of Rights. So Congress had a chance to sort of say, hey, we want to tell states they can't do certain things, but they rejected that call to protect against state violations. So some have said that basically maybe the framers of the Bill of Rights never intended it to apply to the states. In fact, that they had an option to place limitations on state actions, and they didn't do that. And so that kind of could lead one to believe that when it says Congress, it means actually Congress. It applies only to the actions of the federal government, not the states. Because why would James Madison create another amendment that said no state, right? He's the one who wrote the Bill of Rights. If he put Congress, he must have meant Congress. He didn't mean that as like Congress and implied other governments, because he basically stated no states right there. So when it comes to the intent of the framers, kind of, it kind of weighs towards the side of that the framers of the Bill of Rights really did not intend it to apply to the states. That Congress means Congress, and that means limitations on the federal government. Okay, so maybe the framers did not intend for the Bill of Rights to apply to the state. But whether or not we think it did or did not, in a way, it doesn't matter. What matters is whether or not the Supreme Court of the United States thinks that the Bill of Rights applies to the states. And that's what this case, Barron versus Baltimore, is about. This is a case where the court is asked to answer the question of whether or not the Bill of Rights applies to the state. That's what this case is about. And it's a really cool case because, like, one of the reasons I really like teaching civil liberties is because civil liberties is about real people's lives and the way that their lives have been impacted by the actions of government and sometimes harmed by the actions of government. And that not only do they feel like the actions of government have harmed them, but they feel like that these are liberties, these are freedoms that the government is not supposed to take away from you. So that not only are they maybe harming you, but they're harming you in a way that involves the taking away of your personal liberties. And that's what this case, Barron versus Baltimore, is about. It deals with the concept of eminent domain, which some of you might have heard about, and a provision in the Fifth Amendment that's known as the Takings Clause. Okay. And so there's the Fifth Amendment. We'll be talking a lot about the Fifth Amendment as we move forward in the second half of this lecture, but also as we get to the rights of the criminally accused, because the Fifth Amendment deals with that you can't be tried twice for the same crime. It deals with the concept of double jeopardy. It talks about how you cannot be forced to incriminate yourself, but if you plead the Fifth, right, you have the right to remain silent. But also, I mean, there are many liberties in the Fifth Amendment, and one of the liberties says basically that government cannot be taken from you. Okay, and so or the government can't take property from you. Okay, and so eminent domain is this idea that if the government needs land, okay, that let's say the government needs land to like build a highway, or that there's some reason for a government to basically take away your land, okay, your own private land. Government can do that. Government can take away your private property. But the Fifth Amendment says that private property cannot be taken for public use without just compensation. And that's what's known as the Takings Clause. And so that's a liberty that you have. That's a protection that you have. That while the government might very well need for, government interests use, like building a highway or building an airport for military jets or whatever, right? Government can do that, but if they take your private property, they've got to give you just compensation for it. And that's basically what Barron versus Baltimore is about. So, as you're reading the case, you should, sort of ask yourself questions. And on the next slide, I'll tell you the story of Barron versus Baltimore. But ask yourself, who is John Barron from Barron versus Baltimore? It's Barron versus the city of Baltimore. So what's his beef? What's he pissed off about? Like, why is he suing the city of Baltimore? Ask yourself, he thinks he's been harmed by the city of Baltimore. Well, how has he been harmed by the actions of the city of Baltimore? And why does he turn to the Supreme Court to find a remedy for this harm? Remember when we were reading Marbury versus Madison, it's sort of like, William Marbury was harmed. He never got his commission, right? And so he turns to the courts to get remedy for that harm. And that's, it's a case, it's a controversy, and that it's justicable, right? The court can hear it, or can they? We'll find out in Barrett versus Baltimore. And so this is what, ask these questions as you're reading this case. Okay, so let's talk about the facts of the case of Barron versus Baltimore. It's a really cool case. And to get you in the mood for it, there's a picture there from the Baltimore Harbor. And while this case is from 1833, couldn't find a picture that far back. I did find this picture from 1849 of the Baltimore Harbor that's viewed from Federal Hill in the city of Baltimore. And if any of you have ever been to Baltimore, Baltimore is a city in Maryland, and it's a seaport. It has been for its entire, like existence. It is, there's the Chesapeake Bay that comes up into that area that's like coming off of the Atlantic Ocean, and so a lot of people make their livelihood Maryland or Baltimore being a seaport, and that's exactly what John Barron, that was his livelihood. And so, as you've read, or as you will read in your textbook, this is a case about the city of Baltimore making improvements to its city streets at this time period. And so Baltimore was a really big, growing, advancing city at this time period. And its streets were really in disrepair. And so they wanted to make basic improvements to the street. And so the city of Baltimore engaged in this street improvement project. And as a part of the street improvement project, that in excavating and changing the streets, it had an impact on the waterway that was leading into the wharf. And so there were certain creeks that led into the wharf in that area. And the improvements sort of basically messed up the flow of water. And the impact of that mess up of the flow of water resulted in a lot of silt and gravel being funneled into the wharf. And, that the Baltimore Harbor is just known at this time period for having really deep water. And deep water is really important for a seaport because you want large boats to come into the wharf and you want them to not like get stuck in the sand or whatever. You want it to be a lot of water so that they can freely come in, unload their goods, and leave. Now, John Barron was a wharf owner, and he had one of the most profitable wharfs in this area because his wharf had really, really deep water. But that all changed when they started doing the improvements. That suddenly his wharf was basically so filled up with gravel and silt and sand that basically it was nearly impossible for ships to come and dock at his wharf. And so basically he lost his livelihood. And that was his harm. He was harmed by the city of Baltimore for basically taking away his livelihood, his private property, his business, because of their city improvements. And so he's sued the city of Baltimore, saying that they had violated the Fifth Amendment's eminent domain, the takings clause that we talked about in the last on the last slide, and basically saying that his rights were violated, and that on appeal for the decision, it was found that no, his rights weren't violated. So, like any good American, he turns to the Supreme Court and he takes his case to the Supreme Court, making the argument that the city of Baltimore violated the Fifth Amendment's taking clause when they basically put a bunch of silt and sand into his wharf area, basically taking away his livelihood. And he felt that like the taking clause says, like the Fifth Amendment says, that you can take that property from me, but you've got to give me compensation for my loss. And that's the remedy that he was seeking. And he's hoping that the Supreme Court could help him with that. Okay, so the question before the court in Barron versus Baltimore is, does the taking clause of the Fifth Amendment apply to the states? And as you know from reading in the text, or as you will know now, the holding is that no, it's a unanimous decision. That in a 6-0 decision, they said that no, the takings clause of the Fifth Amendment does not apply to the actions of the state or the actions of a city. It does not apply. And that not only that the court doesn't even have the authority or the jurisdiction to hear this case, because the Supreme Court can only hear cases that deal with federal issues. And since the Fifth Amendment doesn't apply to the states, this isn't a federal issue or a federal matter, so they don't even have the jurisdiction to hear this case. What's the reasoning? Now, remember, Marbury versus Madison was a little bit harder to read, the excerpts from the opinion. This will be a lot easier for you to read, okay? So don't give up. The later cases are even easier to read, but this is pretty straightforward. And what the reasoning is that they say that that looking at the Constitution itself, in the articles of the Constitution, it clearly differentiates between the national government and the states. And do note that in the ruling, in the opinion of the court, they refer to the national government as the general government. Okay, so that could be a little confusing, but when you see the word general government, it basically means the national or the federal government. And so they say, look, there are two major places in the Constitution where that the Constitution refers to the national government and it refers to the states separately. In Article 1, Section 9 of the Constitution, it basically places limits on what Congress cannot do. And then in Article 1, Section 10, it places limits on what states can do, right? So basically the ruling is, it's like, if they wanted to place limits on states, they would have done it, because in fact, when writing the body of the Constitution, the 7 articles, they distinguished between Congress and the states. And so basically that, like we were saying before, Congress means Congress, right? If they wanted to say that Congress shall make no law in the Bill of Rights, they would have, if they didn't want it to be just Congress, they would have said Congress and states, and they didn't do it, and so it doesn't apply to the states. They basically said also that if states wanted this limit, they would have included it in the discussions of the ratification. Remember, there were all those discussions as states were deciding whether to ratify the Bill of Rights, and never came up. They weren't like, hey, let's change it to states. No, they were fine with Congress. And they also could have included this in the state constitution in Maryland, which they haven't done. So much like William Marbury, who never got his commission, John Barron, he was, sorry my language, he was shit out of luck. He couldn't find remedy for the damages at the Supreme Court, and unfortunately, due to the actions of the city of Baltimore, he basically lost his livelihood. All right, so Barron versus Baltimore is an important case for many reasons, but in particular for the incorporation of the Bill of Rights, because it provides a clear answer to the question of nationalizing the Bill of Rights. The Bill of Rights protects people from the abusive actions of the federal government, not the state governments. And so it's that at this point, that we know the answer to the question. The Bill of Rights does not apply to the actions of state governments. Do you agree with the decision of the court? I mean, I doubt anyone would be like, sorry. I mean, I'm sure everybody feels bad for John Barron. I know I do, right? And so, I mean, I'm sorry that John Barron, didn't get a remedy from the Supreme Court, and I don't think he ever did from any remedy. But when it comes to the decision of the court, I think they offer a fairly compelling case that there was no intent for the framers to apply the Bill of Rights to the states, and in fact they were very clear in their use of language. They used the word Congress and they used the word states, and they didn't use those interchangeably, so that we could sort of feel confident that they knew what those words meant. Ask yourself what in legal, we learned those legal methods, which legal methods were used. Well, clearly originalism, right? Because they're sort of like looking back at, Article 1, Section 9, Section 10, so that the framers kind of intended the powers to be separate between national state government. But really it was pretty much of a textualist reading as well, right? Congress means Congress. States means states, right? That they looked at the text of the Constitution and they applied it. All right, so as we know, since we know that the Bill of Rights applies to the states, we know that the Barron decision is not the final word on incorporation. That there's a big sea change that happens after the Civil War. And that sea change, well, there's a lot of sea changes, right? But after the Civil War, there are amendments that are added to the United States Constitution. They're known as the Civil War amendments. And they're the 13th Amendment, the 15th Amendment, and then the amendment that is most pertinent for our discussions today is the 14th Amendment. And it's on the next slide that we'll look at the provision within the 14th Amendment that is important for our discussions about the incorporation of the Bill of Rights. The 13th Amendment abolishes slavery nationwide. We did have the Emancipation Proclamation, but that when the Civil War was over, there was no guarantee that states couldn't reinstate slavery, because the Emancipation Proclamation had to do with wartime provisions. And so the 13th Amendment says that, it abolishes slavery. And the 15th Amendment comes after the 14th Amendment, obviously, and that is the amendment that prohibits states from disenfranchising people based on their race, color, or their servitude. And it's fully realized then, saying that you can't deny people the right to vote. It's fully realized not until the Civil Rights Act of 1964. So for those of you who took American government, just a little background there. But it's the 14th Amendment that we're interested in because it's the 14th Amendment that's used to incorporate the Bill of Rights to the states. So let's look at the provision that's most important for our purposes from the 14th Amendment on the next slide. Now let's look at the provision of the 14th Amendment that's important for the incorporation of the Bill of Rights. Now keep in mind that the Civil War amendments, in particular the 14th Amendment, was designed to basically place a check on these southern states that are coming back into the Union. You have southern states that secede from the nation, and as they come back into the Union, into the nation following the Civil War, that there are concerns that the southern states will not change their ways. And so there were provisions that were placed in the Constitution and also the Reconstruction laws that came out of the Republican Congress, following the Civil War. These are all efforts to make sure that that place a check on the power of Southern governments to make sure that they did not continue to violate the rights of people who lived in their states. And so the 14th Amendment, the Section 1 of the 14th Amendment, it says that all people born or naturalized in the United States and subject to the jurisdiction there are citizens of the United States and of the state wherein they reside. And then in yellow, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And then in orange, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. And so this is that does a lot of things. The 14th Amendment is crucially important to the pursuit of civil rights and civil liberties in the United States. The first part of the 14th Amendment is saying if you were born here, you're a citizen, because you could have easily seen after the Civil War, southern states would have looked at free people who used to be slaves and said, sorry, Charlie, that you used to be a slave. We ain't going to let you be a citizen. No, not after the 14th Amendment, because by that time in the 1860s, all the people who were slaves were born in the United States. So that if you're born here, you're a citizen. It also says that it's telling states what they can't do, right? So that's where we're going to see that the 14th Amendment is used as an avenue to incorporate the Bill of Rights. It says states can't make laws to take away our privileges or immunities. It also that citizens of the United States have. Also, states can't take away a person's life, liberty, or property without due process of law, which actually is a provision in the Fifth Amendment, but that because of Barron versus Baltimore, that provision doesn't apply to the states. Here it says no states can take those things from you without the due process of law. And so it's those provisions that we look to say, maybe we can use those provisions of the 14th Amendment to incorporate or apply the Bill of Rights to the states. So where I highlighted in the 14th Amendment, those two clauses have names. The highlight in the yellow is known as the Privileges or Immunities Clause, and it reads, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And we'll talk more about what that means in the next lecture. And the part that was highlighted in the orange is known as the Due Process Clause. And again, there's a Due Process Clause in the Fifth Amendment, but it's also in the 14th Amendment. And it's that in the 14th Amendment, it's the Due Process Clause that applies to the states. Nor shall any state deprive any person of life, liberty, or property without due process of law. And we'll talk about what that means in the next lecture. Okay, so in the next lecture, so this lecture is sort of like, do the Bill of Rights apply? And then understanding that the 14th Amendment is what's going to be used to incorporate the Bill of Rights to the states. In the next lecture, we're going to look at the cases that use these clauses, both the Privileges or Immunities Clause and the Due Process Clause, to incorporate the Bill of Rights. And the Bill of Rights is not incorporated all at once. It's not total incorporation. It's selective incorporation, and it goes case by case by case by case. Spoiler alert, the privileges or immunities clause is a dead end. It's used in one case, it fails, and it's the due process clause that's used to incorporate the Bill of Rights to the states. So we're going to look at those cases in the next lecture, and then we're going to talk about the way that there was an incorporation test that was developed. And this is going to become really familiar to you as we move on throughout the course of this semester. The Supreme Court develops tests so that we know whether or not, in this case, liberties apply to the states. But we're going to have tests that tell us about whether or not provisions violate the freedom of speech, or whether or not you have tests telling us whether or not the actions of state government establish a religion, etc. It's like a standard that's used to help us to help not just the Supreme Court guide its decision making, but it's a standard that is used so that state governments and local governments and federal governments can know what is and is not constitutional. So they're sometimes called standards, and I prefer standards, just joking, because I own standard poodles, and those aren't my poodles, but well, what's a lecture without a picture of a poodle? All right, thanks for listening, and I will talk to you again in the second lecture. Talk to you later.